afternoon. It is Monday, June 20th, and we welcome you to another excellent webinar with Jeff Goodis. This is Alan Gassman from Gassman Law Associates. We represent many, many physicians in their estate planning, corporate, and regular business representation. And then when our physician clients get into litigation, depositions, and things like that, we'll answer the questions we know and then call in an expert like Jeff Goodis. Jeff represents physicians in litigation matters, most notably including malpractice defense and similar situations. Jeff is with the law firm of Thompson and Goodis in St. Petersburg. Welcome, Jeff.
Thanks, Alan.
Jeff, this program today emanates from so many questions that I get from time to time from physician clients who are determining whether to be deposed, when they have to be deposed, and how the deposition will work. So I thought that this would be an excellent knowledge product for both you and I that clients in future years can go ahead and look at. And I want to really thank you for all of the hard work you've put into the PowerPoint. And I'm going to turn the program right over to you here.
Thanks, Alan, and welcome to the doctors. And I'm looking at the list of attendees. I actually see people I know, so that's kind of neat. The genesis of this particular PowerPoint was for grand rounds at the University of South Florida a couple of years ago, and so what you'll find is that I'm going to click through some of the stuff fairly quickly because it's about the nuts and bolts of giving a deposition, how to give a deposition rather than some of the logistics surrounding getting it set up, etc. I'll cover, I think, generally both of those points in this presentation. But if you have any particular questions, certainly I think this provides a way that you can ask them, and I'll try to save some time for that. So we'll just move right into the process here.
Super.
So when we talk about rates of payment, I think that what Alan was talking about was the idea of what type of deposition you're giving. And as a doctor, you will often be giving depositions as a treating physician, and or you may be asked to give depositions as a fact witness, or you may be asked to give depositions in an expert role. And each of those things has a potential different cost, fee structure associated with it, including potentially workers' compensation for any of you who do that type of work, which has a completely different fee schedule potentially built in by the court. But let's talk about those things and the importance of how the courts are looking at those things. If you sign up to be an expert witness in a deposition, as a physician you're asked to give us an opinion on causation or standard of care, you can pretty much set your own rate. The sky is the limit, so to speak, and we have experts in certain fields who charge as much as $1,000 an hour, $1,200 an hour for their time. That does not mean, however, that the lawyer on the other side of the equation, let's assume you're a plaintiff's expert in a medical negligence case, you may have struck a deal with that lawyer to pay you $1,000 an hour. That doesn't mean that the lawyer for the defense has to pay you $1,000 an hour. All they have to pay you is what the court determines is reasonable. And I can tell you that here in Pinellas County, Pasco County, and to some large degree Hillsborough County, you'd be hard-pressed to get a judge to say that the doctor's time is worth more than approximately $400 an hour. And in that situation, two things come about. If the lawyer opposite comes to the table and says, look, I'm willing to pay the doctor $500 an hour, but I'm not going to pay him more than that, pay him or her more than that, you sort of have two choices. One is to challenge that, let the court determine what the appropriate fee is, and in those instances what's going to happen is they're probably going to take the highest fee charged by the opposing counsel's expert and apply that, or they're going to apply in Pinellas, Pasco County $400 to $450 an hour, and then it's up to you and you're the lawyer who retained you with regard to whether you're going to get to charge the rest of that, maybe charge it to them rather than the opposing counsel. If you're giving a deposition as a fact witness, that is you're treating a patient and one of the lawyers is trying to take your deposition, officially they could take your deposition at any time and at any place by sending you a subpoena and demanding that you be there and pay you a witness fee, which I think currently is $10. But most lawyers won't do that because they'd like to have your cooperation. They'd like you to testify honestly and forthrightly and not be affected by how they see your fee. And so they're going to ask you to charge a reasonable fee, and as I said, I think the courts in Pinellas and Pasco County are going to determine that to be in the $400 to $450 range. So you need to keep those things in mind as you're testifying, or the method or the realm in which you're being requested to testify. There's a huge difference between testifying as an expert witness and testifying as a treating physician, even though as a treating physician you may ultimately be asked for expert opinion.
That's the next screen. There it is.
And so we talked about the differences between a compensated expert and a non-compensated witness of fact. If you're speaking with a lawyer in anticipation of the deposition and they start asking you questions about your opinions, whether the opinions be about standard of care, causation in a motor vehicle accident, etc., just because you're being asked to give expert opinions doesn't mean that you're an expert witness, because in Florida, it's important for you to understand that retained experts, those people who we go out and hire to testify, versus treating physicians are treated differently. And in fact, non-retained experts, treating physicians, can give expert testimony without being retained and without counting against the side who's retaining experts. So if you're a neurologist and you treated a patient and you think that the motor vehicle accident caused the patient's injuries and you give that opinion, that does not preclude, in most instances, that lawyer from going out and finding a paid expert to say the same thing. And so, again, it's a matter of what is the lawyer who's asking you to testify really looking for, what are they willing to pay, and as I tell my clients with regard to records requests, which I think is one of the most important things that a doctor can do, which is respond to records requests, and unfortunately most of the time they assign the lowest person on the totem pole to that job, it's important that you be active in the decision of when, where, to whom, etc., that you're going to give a deposition, because it could have particular negative consequences in some instances. So that's where we ask, let me go back one, do you have your malpractice insurance carrier involved if this is a patient you've treated and there's questions about that treatment? In other words, do you have any concerns? Are there any red flags? In most instances, if you have malpractice insurance and you say to the carrier's representative, and most of them have local representatives in the Bay Area, at least the main 2 or 3 have offices in Tampa. It's important to be in touch with those people to say, look, I've been asked to give a deposition. The patient is a little squirrely, or there might have been some postoperative complications, whatever the case may be, and I'd sure like to have coverage for that deposition. Most malpractice carriers will provide you with a courtesy defense, meaning that they'll provide you a lawyer to review your records, talk with you about the case, arrange the deposition, and take care of those things for you so that you don't get yourself into any potential problem.
Well, that's certainly a nice thing to be able to draw on.
It is, and I think that a lot of physicians don't know that their carriers provide that service. Most of the carriers do. Some of them do not. If you do not have an issue with the patient, it's a motor vehicle case, there's been no complications, not something that you're particularly concerned about, then you probably don't have to involve your insurance carrier, but you should definitely be involved yourself. And by that I mean you want to be sure that you know going into the deposition who's taking the deposition. Is it the lawyer for the patient? Is it the lawyer for someone who's claiming the patient is not injured? Has someone asked to speak with you? Have you had an opportunity to review the records? The best preparation for deposition is to know your chart, because that's what you're going to get asked about 9 times out of 10 or 99 times out of 100 is probably more realistic. So what do we want to talk about as it comes to the idea of giving a deposition? And there are this part of the program deals to some large degree with that case in which you are a defendant, but I will try to tailor it for those circumstances in which there's no one has an eye toward making you a defendant. And I think that most of what we'll talk about from this point forward applies regardless of whether you are a defendant or simply a witness. So what do we want to talk about? Statements that you might give, people you may speak to before you give a deposition, how you can give a successful deposition, whether you are a witness for your patient, whether you are a witness who has done a compulsory medical examination, whether you're being asked to give a witness as a defendant physician, or whether you're giving expert opinion. Most of what I'm about to tell you would apply across the board. And perhaps most importantly, from my perspective, is that I want my clients, whether they be defendants in a medical negligence case, experts, or simply a treating physician, to come across to whoever's listening to that deposition as what they truly are. You know, look, I'll single Jimmy Post out. He's on this webinar. I can see from my list of attendees. He's not going to charge me
a royalty now.
Yeah. Dr. Post is someone I know to be a caring, compassionate, careful guy, someone I know has his patient's best interest at heart. When you employ certain deposition tactics or strategies, you can come across as that person who you really are, while if you don't, you may come across as someone you are not. And I think the goal of any physician should be to really be that caring, compassionate, careful physician that you practice as, whether you be that as an expert, whether you be that as a defendant, or as a fact witness. And most of all, what you want to avoid, certainly when you're a defendant or an expert witness, is the God complex. Unfortunately, we couldn't get the PowerPoint via the webinar to have that famous line from Alec Baldwin when he is a defendant physician in a deposition, and he talks about how when the patient's family goes to the chapel and prays to God that their mother, brother, sister, father, grandmother pulls through the surgery, they're not praying to God, they're praying to me. I am God. And many of you in the practice of medicine, surgery, or medical treatment, do to some large degree hold patients' lives in your hands. And many of you will be asked questions about the idea that if it was but for your treatment, this patient would not have survived, or but for this accident, this patient would not have had the problem that they have. And to me, while that's very important to make clear, it's also very important to do it without everyone thinking, you know, why does that person have such an inflated view of their own self-worth? That doesn't mean that you shouldn't have that. Look, you have worked you've worked harder than most people to get to the point that you're at in your career. It's not easy to go to college, medical school, internship, residency, fellowship, etc., and 10 or 15 years later go into a practice that is fraught with particular peril, from patients to lawyers to administrators to Medicare to Medicaid, whatever it may be. It's a lot of pressure, and you need to be compensated for that, and you need to be considered of your time, and you're up early doing rounds and you're out late doing rounds and those types of things. Unfortunately, not everyone who does what I do is respectful of that, and so you need to be very careful in the process, which is why I say in any process that you want to be sure that you're involved in that decision-making process and not relegating it to the lowest person on the totem pole. Most of you, I'm sure, know what a deposition is. It's really nothing more than responses to questions posed by lawyers. You don't get to ask questions during depositions. That's frustrating, especially if you're not an expert in a particular area. They may be questioning you about a neurosurgical case, and you're a primary care provider, and they want to know a patient's history. That doesn't matter. You need to just answer the questions the way you know how to answer a question. Remember, they're often videotaped, that the testimony will be transcribed, and that if you are a defendant, it's the old line, what you say can and may be used against you in a court of law. If you are a defendant or a plaintiff in a lawsuit, anything that you say in your deposition can be used at any time for any purpose during a trial. And so you need to be particularly aware of that. No matter what role you're in, and I'll quit repeating them ad nauseum, the purpose of the deposition is for most accounts to discover what you're going to say, or to perpetuate what they already know you're going to say for a later time. And so that's why consideration should be given to whether the video, or whether there's going to be a videotape of the deposition, or whether it's simply going to be taken down by the court reporter and transcribed. One of the things that Alan and I talked about is whether, as treating physicians, you want to ask whoever's taking your deposition to videotape it so that you don't have to later appear at a trial. If that's the type of practice you have, where attendance at a trial later down the road would be difficult, scheduling difficult, it may interfere with your patient care, etc., that's a perfectly valid thing to ask. Can you guys videotape this deposition so that you can use it at a later time?
And that's a great question, Jeff. Absolutely. And a lot of times the lawyers setting the deposition don't think about it, but you have to think about it for them.
And that's important, because there also may be a number of situations where you don't want to be in the I've just lost the, there it is. Whoops. Did we all get back to slide 1?
You got to start over, Jeff.
Sorry about that. I'm not sure what happened.
Pleased to be here. It's 5:30. We're in 12 o'clock.
I'll get right back to it. But there are many instances where you may not want to give a video depo, either because you're not sure where the case is going, you're not sure the purpose of the deposition, and you need to be sure that you understand those things before you ask that question. I also think, and I might as well talk about it now, the decision as to where to do the deposition is important. And it doesn't sound like that's that big a deal. Certainly for you, for most of you, the most convenient thing is to have them come to your office and do a deposition. But remember the last point on this page, that oftentimes depositions are taken to get an overall impression of you as a witness, to determine what effect you may have on a jury, to determine whether you're someone that they might want to pursue in a claim later if the statute of limitations is not run. For that reason, I encourage my clients to not hold depositions in their offices. Most of you, if not all of you who practice, have literature in your lobbies. You have your certificates of your training hung in your office, things you should be proud of. And in your office, proper, you have family photos or those indicia of your membership in particular organizations, which may have a bend one way or the other. All of those things, when someone comes to your office, including what may be on your shelves, what journals, etc., are potential fodder for examination. And there's been more than one occasion where I've been in the deposition of a witness who's testifying, been asked to testify by the plaintiff as a fact witness concerning causation and a medical negligence claim, and they have a book on the shelf, and I go to the book, and during the deposition the witness gives testimony that's inconsistent with a book that I found and leafed through during the deposition. And it's always fun when I get to say, doctor, I pulled this book off your shelf, and you just testified that in most cases, a herniated disc is something that will stay with a patient, but this book on anatomy says that herniated discs in patients, and I'm making this up at this point, 30 to 45 years old are present, and then in many cases the disc, with treatment or even without, will reabsorb, etc. What do you say when you're that person? And that was a kind of a cruddy example, but the reality is, do you really want someone in your office looking around? I will not, as a medical malpractice defense lawyer, in most instances, allow my client to be deposed in their office because I don't want someone snooping around the office. And that's something you should consider in any instance in which you're being asked to give testimony. And we just talked about that. Location, location, location. If there's anybody online who's, heavily invested in the real estate market right now, I'm sure they're upset about it, but also you know that location, location, location is important. And we've talked about, videotaping and whether that's something you want to do versus not. When I talked about, or we've put this slide together, we wonder about scheduling. And it's particularly difficult in many instances to schedule doctors' depositions. These are the nuts and bolts. Just this week, and we're already on Tuesday, so we were dealing with, late last week, Friday and yesterday, I get a call from a doctor who says, the lawyer in this case has scheduled my deposition for Wednesday of next week, and I can't be there. I'm going to be on vacation in Tennessee. And I say, all right, doctor, send me the subpoena and let me take a look at it. As soon as I look at the subpoena, two things come immediately to mind. One, it's a blind subpoena. In other words, it was set clearly by the lawyer at the lawyer's convenience in a place that's clearly convenient to the plaintiff's lawyer's office. It's in the same, or the defense lawyer's office. It's in the same building as the defense lawyer's address. And the doctor's in St. Petersburg, and the deposition set in Tampa. The second interesting thing about the subpoena is that it's drawn on an Illinois court, meaning that the case is actually pending in Illinois, but the patient had treatment in St. Petersburg. And so as I look at it, I call the doctor and I say, doctor, I've looked at the subpoena. I can't really help you because to intervene in this case, I'd have to go to Illinois. I'm not licensed there. I can't get the local court to do much about it because even though they issued the subpoena, it was under the authority of the Illinois judge. But let me ask you something, doctor. Were there any conversations between your office and the lawyer who set this deposition via this blind subpoena? No. So you're telling me that they just sent you a subpoena without ever asking to set your deposition? Well, we got a number of requests, but we didn't respond to them because I'm really busy.
Right, that's what I hear over and over again.
Well, and that's not any big surprise. After making repeated attempts to schedule a deposition that was convenient for the doctor and getting no response, they sent a subpoena. And the reality is, he said, well, what if I go to Tennessee and take my vacation and I don't show up for the deposition? Look, practically, the reality is probably not much. But if the lawyer really decided to push it, all that lawyer would have to do is show the judge in where the commission was appointed in St. Petersburg. That means that the Illinois court asked the Florida court to issue a subpoena on its behalf, show the Pinellas County judge that subpoena, and say the doctor did not appear, and the court could issue a bench warrant for the doctor's arrest. I have actually seen bench warrants issued to St. Petersburg physicians who are notoriously bad about scheduling depositions or being willing to schedule depositions. If you or perhaps one of your higher level staff persons responds to those requests and says, look, the doctor's very busy. He's he does rounds at 5 a.m. He does rounds at 5:30 also. But we can do Wednesday at 5 o'clock, and the people are polite about it and reasonable about it. You'll never get a blind subpoena like that. If you don't, most lawyers will try to figure out what it is you do. Do you play golf on Wednesdays at 1:08? Do you play tennis on Fridays at 5:15? It's not that hard to figure out. You'd be surprised at how easy it is to figure out your schedules. And a good investigator, most law firms have them, can find that out. And guess when you're going to get subpoenaed? When you're on vacation, when you're supposed to be playing golf, when you're supposed to be playing tennis, etc. We have inherent in any litigation the power of the subpoena, and if pushed, lawyers will use it. Recognizing, if you're the defense lawyer and the doctor's been treating the patient for, TMJ syndrome, and the records indicate that the patient's motor vehicle accident was the reason the patient has TMJ, if I'm the defense lawyer, what do I have to lose by setting it at a time that's convenient for me? You're going to say what's in your records anyway. Wouldn't you rather have the cooperation associated with scheduling it reasonably? Now, look, not everybody does that. I'm not suggesting that that's an abuse of the system, but there are plenty of doctors, and interestingly, there are a number of physicians who are very active in the personal injury realm who make it difficult to schedule depositions, etc. Those doctors become the targets of lawyers, and that's not something you want to be, because I can tell you that if you become one of those targets, whether it's on the plaintiff side or the defense side, some people will act with absolute avarice to try to discredit you or to try to make life difficult. The best thing any doctor can do is try to be cooperative in the process, and especially if you're someone who works in the process. You do a lot of comp patients, you do a lot of comp examinations for insurance companies, whatever it may be. Being non-cooperative is really a problem. If you say I only do depositions at 4:30 on Wednesdays, I can tell you the likelihood is that most lawyers are not going to agree to that, and most judges are not going to make them agree to that.
Yeah, Jeff, let me just chime in here, having represented a lot of physicians who got cross-haired with litigation lawyers. With a lot of litigation lawyers, there's an ego thing going on. There's also a disorganization thing going on. There's a failure to plan in advance. So you're absolutely right. As soon as a physician knows they may get their deposition taken, at least having one of their better staff people call the paralegal for the lawyer who's trying to schedule it. Be very friendly, as you should be with everybody. Not the doctor, but the person who works for the doctor. Be friendly. Explain his schedule. Ask politely if he's going to be paid or if she's going to be paid. Ask politely how late in the day it could be. Ask when the trial is. Find out about it. Make friends with the people on the other side. Then maybe call your lawyer, call your malpractice carrier, and just get it squared away. But sometimes these lawyers will bend over backwards, and they will come to your office at 7. I mean, they will meet you at a neutral site at 7 p.m., and they will videotape it. You can't get what you don't ask for, but you always want to ask nicely. You don't want a litigation lawyer to target you as the person to be bullied on for the day. Go ahead, Jeff. Sorry.
Thanks, Alan. No, that's all right. I think the reinforcement is there. I don't mean to sound ominous or threatening, but look, I deal every day with lawyers who are what Alan described, and who are 2 weeks before trial, and they have to have the depositions done, or the judge isn't going to let the person testify or isn't going to allow the testimony to be presented, and it's a major inconvenience. It is inappropriate and maybe even unprofessional in some instances on the lawyer's side, but we still have the power of the subpoena. So I want that to be clear in this process, that you are being faced with the potential of something very serious.
Now, Jeff,
that's a nice segue.
Yeah, we had scheduled
go ahead.
this. Yeah, I was just going to say we scheduled this for half an hour, but you are doing a really good job. Everyone who started is still with us. We have a lot more people than we at first thought we would. So, Jeff, I think you should just take your time here.
All right. Well, I'll keep going, and I'll try to speed up a little bit because I know that I've been going a half hour already here, and just try to get through some of these slides more quickly. Obviously, my goal for any of my clients is that they become, a solid witness in whatever role that they're in, whether it be, expert, treating physician, etc. And I think there's a huge difference in giving testimony as a defendant or giving testimony as a fact witness, just like there's a big difference between giving testimony in a deposition and giving testimony at trial, depending on what your role is. If you're a defendant, you want to answer questions, only the questions asked. If you're an expert, you want to answer questions in a much different way. You want to be sure that the other side understands the theories and the knowledge. If you're a treating physician, your responses should be to the questions asked, and should not contain editorial comments or gratuitous opinions concerning things that are good or bad for whoever the case may be about. In other words, your job as a fact witness should be to respond to questions. And so when I talk about that with clients and others, whether they be they'd all be clients, but whether they be someone who is a defendant versus someone who's a prospective defendant, or someone who is just a fact witness, the rules don't change. And the number one rule, of course, after you're sworn to tell the truth, is to be honest. But I always tell my clients that in addition to being honest, you have to ATFQ. And no matter what your role is, and I see we have mixed company on the webinar, and so I'll try to be polite and politically correct. Answer the freaking question. That's what ATFQ means, because you have to answer the question asked. You can't go to a deposition and not think about answering as clearly as possible. And so it's important. Answer the question. Don't try to determine what someone wants. Answer what the question asked is. It doesn't matter what role you're playing in that regard. You have to be respectful, and that's part of this process. My position on taking depositions is simple. If the witness is respectful of me and my time, I will be respectful of them and their time. If they're not, then I may be a little more aggressive, a little tougher, a little more interested in things that may not be in the doctor's best interest. That's not to say that I would ever, hopefully ever, cross the line. It's just a matter of how the deposition is conducted. I always start out with the theory that I will be respectful to the individual giving testimony, including expert witnesses who I know are not particularly honest or forthright and are in the process for a living. I still start out as respectful. And I have taken the deposition of witnesses who I think, based on deposition transcripts, are going to be rude and combative and non-responsive, and I get there having never deposed the witness before, and I find them to be charming and responsive and reasonable. And I think that stems from how I started deposition. And I don't think there's anything wrong if you're in a fact witness situation or an expert witness situation, and I wouldn't recommend this as a defendant, but a fact or that of saying simply, I don't understand the reason for your aggression. I don't understand if there's something that I've done or said that's got you upset. I apologize for that. Let's start again. I'll just run through some of these things. You can read them. You got to be patient. If you don't understand something, you've got to ask that it be rephrased. Don't ever answer a question you don't understand. You don't have to. If you don't know or you don't remember, you shouldn't answer the question. You should simply not guess or speculate. Those are no-nos. That's an absolute don't do that. If you don't know or you don't remember, say so. Correct your mistakes. If you make a mistake and the second line says don't correct the plaintiff's attorney's mistakes, that's if you're a defendant, But if you make a mistake during a deposition, it's absolutely appropriate if you recognize it, half an hour later or 2 hours later to go back and say, you asked me this question and I gave you this answer, but I made a mistake. I need to fix it. Absolutely correct your mistakes. When we're on videotape, it's important that you listen to the question, and I've seen many depositions where a witness, whether it be a fact witness or an expert, looks down the end of the table to the video camera, and listen, unless you're Brian Williams or Katie Couric or somebody like that, you're going to look like a deer in the headlights. You need to be looking at whoever's talking to you, because that's human nature. That's how polite people respond to people speaking with them. And so my goal for any physician that I represent who's giving a deposition in any capacity is to simply look at the person speaking to them, never look directly at the camera. You want to certainly listen to your attorney, listen to the other attorneys, and listen to yourself. Many of you probably think that a deposition is about talking. To me, the most successful deposition is where you have exercised your listening skills. You've listened carefully to the questions asked and responded thoughtfully to those questions, rather than assuming you know what is going to be asked and trying to give the answer which you think will bring the deposition to the conclusion the quickest or whatever. Depositions are an exercise in listening. At the end of a deposition of you as a defendant or as an expert or as a fact witness for that matter, you should be tired from having listened carefully and not from necessarily speaking so much. I'm not going to go over the technicalities of objections at this point, probably not that important for these purposes. You know, this is keep it short and sweet, keep it simple, stupid. It's just an idea of, the idea of a deposition is to keep the deposition to a reasonable length by giving reasonable responses to the questions asked, to answer the question. This is something that I think is probably one of the most important points of giving a deposition in any role you may undertake. And honestly, I think this is probably, Alan, the best point for us the point to conclude on, because I think it's the most important. When you give a deposition, I think it's particularly important for you to be able to say, I saw Mrs. Smith and I recommended that Mrs. Smith be seen by a cardiologist because she was having an irregular heartbeat. What I do not think is the right way to phrase a response is to say, we saw the patient and we recommended a cardiology consultation as a result of irregular heartbeat or a syncopal episode or whatever the case may be. Think about this. If you take nothing else away from this process, if you want to be seen as the physician you are, the caring, compassionate, concerned doctor that you try every day to practice as, think about your testimony, how it's being interpreted by the people who are listening to it, whether it be the lawyers, whether it be the jurors, whether it be Mrs. Smith, your patient. Everyone in that room, everyone listening to your testimony has been, is, or will be the patient of a physician. And the last thing they want to think about their doctor is that at the end of the day, the doctor turns to someone on the staff and says, be sure to get that patient an MRI, or be sure that we treat her or we get her consulted with a neurologist. They are people. They want to be thought of as people, and the best way you can build that patient rapport is to refer to them by their name and take responsibility for what's happening in your office by saying I instead of we, and giving that patient a name. Psychologically, I think it's the most important part of relating to your patients, and I'll just add that the best thing you can do for risk management, in addition to keeping good chart notes, is building rapport with your patients. Patients do not want to sue doctors they like. Families do not want to sue physicians that they know that their mother, their father, their brother, their sister liked, trusted, and cared about. And so as you go through the process, as you are involved in litigation, whether it be as a witness, fact witness, expert witness, or defendant, remember that your rapport with the patient and then ultimately the jurors is what may or may not make the juror's decision as it relates to you. I've been going, 40 minutes instead of a half hour. I think it's a good way to end. If any of you have questions, I'm certainly willing to try to answer them. And if any of you have questions in the future, you certainly can feel free to call me. I'd be happy. Just remind me that you were on the webinar, and I'll be happy to try to answer them for you. Alan?
Yeah. Jeff, I'm sorry for the delay there. Had trouble with my headset. That was excellent. I especially agree with what you said at the end, where it makes a huge difference to a patient, and actually, believe it or not, to their plaintiff lawyer who might have already even sued you. If that patient really likes the doctor, it makes a big difference to settlement. It makes a big difference to what happens and how a doctor is treated. Jeff, I can't tell you how much we appreciate not only tonight's program, but all that you've taught us in the past, and all the help you've given to so many physicians, sometimes with more notice than others. So anyone attending, please feel free to send us any emails or questions you might have. Jeff's email address is on the first page of this presentation, jmg@thompsongoodis.com. He can also be reached, of course, at his law firm by phone. This is Alan Gassman, wishing you a fantastic evening, and Jeff, thanks again.
My pleasure. Thank you, Alan. Thank you, doctors.
Good night.